If I have a right to do something, I don't require permission. So if I have a right to keep and bear arms, then I don't require a concealed carry permit. They are contradictions in terms.
This is former Libertarian presidential candidate Michael Badnarik. In this clip, he breaks down how and why 14th Amendment U.S. citizenship has converted all your rights into privileges. I'm going to break down each of his points so that there is no confusion. He is 100% correct. Everything stated in this video is stated in a historical and educational context only.
Did George Washington and Thomas Jefferson have gun permits? No, it was ridiculous. I mean, you were required to have a gun, basically, to defend the United States. So, if they didn't have a gun permit, and we do now, where was the first gun permit? When did we write the first gun permit? Just after what we call the Civil War. It's actually the war between the states. If you have a right to do something, you don't have to ask for permission. White people had rights. Black people were slaves. They had no rights. Well, we passed the 13th Amendment, which says there's no more slavery. Well, gosh, if there's no more slavery, then blacks and whites are all the same, right? So you're going to give the black people guns after you've just had them in chains? And I don't think so. They may be a little upset with us. Giving them a gun may not be a real good idea this week. And so what we did was we gave blacks privileges.
This is a very important point, and one not meant to be discriminatory. It is merely the historical context surrounding how 14th Amendment United States citizenship came to be. In order to understand the significance of the point Michael is making, we must first establish that U.S. citizenship is separate and distinct from state citizenship and does not convey the unalienable common law rights belonging to the people of the states. Do you think this statement is sovereign citizen nonsense? Let's consult Black's Law Dictionary as well as the Supreme Court. First, Black's Law Dictionary, 4th edition, states that the 14th Amendment's significance entitles it to special mention as it created, or at least recognized for the first time, a citizen of the United States as distinct from that of the states. In McDonnell v. State from 1883, the Indiana Supreme Court confirmed that one may be a citizen of a state and yet not a citizen of the United States. Even up until 1966 in Cross v. Board of Supervisors of Elections, the Maryland Supreme Court held that it found nothing which requires that a citizen of a state must also be a citizen of the United States. Finally, the fact that these citizens have mere privileges and not unalienable rights is evidenced in Maxwell v. Dow from 1900, where the United States Supreme Court held that the privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. This means that the U.S. citizen does not have the protection of the Bill of Rights, only government-granted privileges that can be altered or taken at any time.
So blacks were given privileges with the 14th Amendment. How about a marriage license? Did Thomas Jefferson and George Washington have a marriage license? No. Today, just about everybody has one. Where was the first marriage license? Right after the Civil War.
To require a license is to require permission, and the ability to permit is the ability to deny. This means that requiring a license for marriage is to say that marriage is not a sacred union under God, but instead a government-granted privilege placing government in the position of God.
So the first marriage licenses were permission for interracial marriages. And I have a copy of Black's Law Dictionary. Now this is Black's Law 3rd edition. This is about 1870s, I think, somewhere in that time frame. And so it's an old book, and I've gotten a copy of it, and I've looked up marriage license. And it says, quote, a license or permission granted by public authority to persons who intend to intermarry. Right there in black and white. A marriage license is for mixed marriages.
This has a lot less to do with race than it does the legal principles behind the difference between a U.S. citizen and a state citizen. To understand this, we must first look at who federal citizenship was intended for. When the slaves were freed, after spending generations in a state of servility and dependency, many of them did not know what to do. A number of them just stayed on the plantations they were freed from because they knew nothing else, and many others became vagrants and drifters. It is a fundamental principle of law that, in order to be free and exercise unalienable common law rights, one must be independent and not require assistance from the government or anyone else. If an individual is unable to sustain themselves without welfare assistance, there is an ancient and invisible mechanism in law that causes that individual to come under administration, where the government becomes your guardian and your personality, labor, and property are placed in trust and are now subject to the regulations of the administrator. The newly freed men, through no fault of their own, were without property or the skills and knowledge to sustain themselves. They required government assistance and therefore were placed under the administrative guardianship of daddy government as chattel trust property with government-granted privileges. So when one of the people of the states wanted to marry a U.S. citizen, they had to get daddy government's permission because the U.S. citizen is government property. That is why you require a license for almost every activity today.
Well, eventually that was working so well that we just apply a marriage license to everybody. Why do you need permission? If you go to a wedding, how many people are in that contract? Well, you got the man, you got the woman, but that's not all. You've also got the state. The state is there giving you permission. Why? Because you asked. If you ask for permission, that's pretty good evidence that you needed permission. Why would you ask for permission if you don't need it? So you've got the man, the woman, and the state. There are three entities in this contract. So now the state has a vested interest in the outcome of this contract. Well, what is the general outcome of a marriage contract? You put a boy and a girl in a dark room for long enough, what's going to happen? Children. So now the state, because they are vested in this contract, they have a vested interest in the children. How can this social worker come to your door and say, you're not being a good parent, and take your kids away? Because they own them.
Today, with everyone having been coerced into this subclass of citizenship, the government treats marriage as the merger of two commercial investment trusts, and as owner of the trusts and as a party to the merger, the government has a vested interest in the productive value of the marriage, including the children. This Independence Day, I want to remind you of the voluntary nature of 14th Amendment United States citizenship and that it is the linchpin to the entire New World Order agenda. If enough people withdraw their consent to be a U.S. citizen and reclaim their status as one of the people of the states, there will be no more tax chattel to borrow against, as the government could only collateralize its property, not the people, and the banks would fail. The U.S. corporation would default, and the entire debt slavery system would collapse. President Andrew Johnson had said when vetoing federal citizenship that this new class of citizenship was discriminatory and unnecessary, that the avenues of freedom had just opened up for African Americans and all that was required for them to have unalienable rights was for them to learn the law, our institutions, and learn to be independent. Remember, our rights do not come from government. They come from our Creator. Government can only grant privileges which can be taken away. Our rights existed long before government, and in fact the sole purpose for which the people created government was to aid in securing those rights. As it says in the Declaration of Independence, when any form of government becomes destructive to that end, like converting your rights into licensed privileges, then it is the unalienable right of the people and their duty to God to alter or abolish that government.